questions and comments? The Honourable Member for Moncton Riverview Gap.
Thank you, Mr. Speaker. I want to thank my friend and colleague on the Justice Committee for his speech. It's a fairly large canvas, this Act, and I know he didn't get a chance to elaborate on many of the points. And I do want to give him a chance, though, to elaborate what I think Canadians will find interesting and in some quarters disturbing, that people can have their fingerprints taken and retained upon being arrested. It is a very large change in our criminal law. He makes it sound, because he's a good lawyer and a good salesman, as if it's a convenience. It's doing the accused person a favor. Not the accused person, the arrested person a favor. You can go home now, we're just going to keep your fingerprints for life. Can he be more specific than the Act itself in paragraph 39, which, or the bill rather, which attempts to amend the Identification of Criminals Act by just adding the words "after being arrested for," in addition to being, of course, charged or convicted, where fingerprints are rightfully taken and withheld, or held. What kind of offences does he envision? Does he envision that the police forces will, upon application, expunge fingerprints of persons taken from persons who are subsequently not charged or convicted?
The Honourable Member for Edmonton St. Albert.
Thank you, Mr. Speaker, and I thank the Honourable Member and my friend, and I use that word deliberately, from New Brunswick. I always enjoy his contribution to the Justice Committee, and I certainly compliment him on the contribution to this and other debates. As he knows, the Identification of Criminals Act does not currently authorize police officers to fingerprint or photograph individuals in lawful custody until they have been charged or convicted. This often results in unnecessary delays and can prolong an accused individual's stay at the police station. The proposed amendments would streamline this process by adding the authority to fingerprint and photograph an individual who is in lawful custody following an arrest but not yet charged. As the Honourable Member is no doubt aware, there are provisions in the Identification of Criminals Act that deal with these records subsequently if an individual is acquitted, if an individual has his charges withdrawn or stayed. So he's quite right in his preamble that in many instances this evidence is to the benefit of the accused. It will certainly, in certain circumstances, expedite the processing of that individual. He won't have to be detained until the appropriate authorities, whether they be police or the Crown Prosecutor's Office, until they make a decision upon charges. They'll be able to process, get the evidence, allow the accused to be released on bail if there's no primary or secondary grounds to detain him, and ultimately, if the accused is not convicted of an offence, the appropriate applications will still apply.
Questions et commentaires?
Questions and comments? The Honourable Member for Abitibi-Témiscamingue. Mr. Speaker, my colleague is on the committee, but I have the same question as my colleague from Moncton put. I believe that my colleague who just answered has never practiced criminal law, because in Canada, in criminal law, the criminal law is based on the presumption of innocence, and I'll get back to that in a moment. We put the question to the Minister, and this is something that really gives us pause in Bill C31, but I'll get back to that in a few minutes. My question is, why should we put in legislation, why should we change something that works? For example, we have the presumption of innocence. You're presumed innocent until proved otherwise. And we have to understand just how long these anthropometric files will be kept. Now, is this something that anyone could, who would ask for these digital fingerprints? The Honourable Member.
Question et commentaire. The Honourable Member.
questions and comments?
It would be nice if they followed the police recommendations with regards to the gun registry, Mr. Speaker. I want to pursue this. I want to pursue this question of the fingerprinting. The member from Edmonton is incorrect. There is nothing in this bill, and there is nothing in the criminal code presently that requires police forces to do away with these fingerprints. So if an individual is charged, Mr. Speaker, I'm sorry, an individual has his fingerprints taken and is not subsequently charged, which is what this bill allows for, those fingerprints stay on record. They're on the CPIC. They're available to all the police forces across the country, even though the person's never been charged. And this bill does not correct that. It's one of its major flaws. It's probably the only part of the bill that, like my colleague from Abitibi, I've got serious reservations about. So my question to him is, one, why do you not have a provision in here that they're done away with? And secondly, I've spoken to a number of police officers and chiefs of police, and the only explanation I get about this is that it's the reason you're taking fingerprints before a charge is because of convenience. And it's not the convenience of the accused person or potentially accused person, it's the convenience of the police. But when I explore that with them further, I don't find where the convenience is. And I wonder if he could maybe explain that to me, if he understands the process, because as I understand the process, it's not going to make any difference and it's not going to be any more convenient.
The Honourable Member for Edmonton St. Albert.
Well, I certainly respect the Honourable Member for Windsor-Tecumseh, and I didn't mean to misstate the current state of law. What I said, or at least what I meant to say, if I didn't say it, is that police services routinely will destroy fingerprints and photographs at the accused's request when charges do not result in a conviction. Now, I will concede that there's no statutory obligation for them to do so. What I'm suggesting is that many, if not most, police forces in Canada do destroy the fingerprints and the photographs at the accused's request when charges do not result in a conviction. But he will know, because he is a learned lawyer, that courts have stated, including appellate courts, that it is not unreasonable for the police to retain the prints when no requests are made for their destruction or return upon the charges being dropped. So the courts have authorized the retention of those records, including appellate courts in this country. And so I don't think there is any gap or anything missing in the legislation with respect to this. With respect to the expedition of processing of individuals, I've answered that in the question previous from my friend from New Brunswick. Certainly, this expedites the process and allows individuals who might otherwise be detained until the police can make a decision whether or not a charge can be laid, whether or not a charge will be laid. It allows them to be released. They've provided the evidence, the fingerprints and the photographs that have been requested. Then they can be released, all other things being equal, and await the determination of whether there exists evidence to lay a charge.
Questions and comments? The Honourable Member for Mississauga South, a short question, please.
Thank you, Mr. Speaker. And certainly the bill does cover a broad range of issues, but if we only have a short question, let's stay with the fingerprints. Given the member's statements, would it be his intent to address this issue of where they request to say that simply they would be taken on arrest, but if no charge is laid, they would automatically be expunged from the records? Because this amendment is to the Identification of Criminals Act, and this has to be quite unnerving to those who would be arrested but never charged or convicted of anything. Would he support that change?
The Honourable Member for Edmonton St. Albert.
I anticipate that the members of committee, including the two that we've heard from New Brunswick and from Windsor, I suspect they may be proposing such an amendment at committee, and I look forward to that debate at that time.
Resuming debate.